One of the most common questions that we're asked is whether or not people who are subject to the permanent bar are eligible for parole in place. So let's talk about what the permanent bar is and whether or not it makes you ineligible for parole in place. So there are two situations in which someone will be subject to the permanent bar. The first situation is for people who have a total of 1 year of unlawful presence in the US starting from on or after April 1st, 1997. And then they leave the US and then they attempt to come back, or they do come back without inspection. So that means without being admitted or paroled into the US. So if you have the 1 year of unlawful presence, you leave and re-enter without permission, you've triggered what's called the permanent bar. The second situation is when you've been ordered removed, you leave the US, and then again, you either attempt to enter or you do enter without permission, without being admitted or paroled. You are then subject to the permanent bar. If you have been ordered deported, but you've never left the US, this doesn't apply to you. The permanent bar is called permanent because if you fit into one of the scenarios above and you're subject to it, then in order to return to the US, you need to apply for permission after you've been outside the US for 10 full years. And if you're not granted permission to come back to the US, then the bar is permanent because you're not going to be able to re-enter on an immigrant visa as a green card holder permanently. So what does this have to do with parole in place? USCIS has told us that if you're subject to the permanent bar because of the second situation, where you've been ordered removed and you've actually been removed or you've left the US, and then you've re-entered or attempted to re-enter without permission, you are not eligible for a parole in place. So don't even bother applying. Your application will not be granted. But if you're subject to the permanent bar because of the first situation, which is that you have a total of 1 year or more of unlawful presence in the US, you've left the US and then you've re-entered the US without permission or attempted to re-enter the US without permission, then you are presumptively ineligible for parole in place, but you can still apply. So presumptively ineligible means they're going to presume you're not eligible, you're not going to get it. But if you think you can overcome that ineligibility presumption with positive factors, then go ahead and apply and they may grant your application. And why we say people in the first situation need to speak to an attorney and make a personal decision on a case-by-case basis is even if you apply for parole in place and you get over the presumption of ineligibility, meaning that they grant your application, you are still not eligible to apply for a green card in the US. That's not going to make you eligible to apply for a green card in the US. You're still subject to the 10-year bar, which means that in order to apply for a green card, like through your spouse, you're going to have to leave the US for 10 years, stay outside the US for 10 years, and then apply and receive permission to come back to the US before you're eligible for the green card. So people in that first situation who have the permanent bar, is it worth it to apply for parole in place, bring yourself to the attention of the government, give them all your background information for a work permit and a social security number? Every situation is different. And as always in immigration law, there's no one size fits all solution. And there may be other ways for people with the permanent bar to get a green card, such as through a U visa or cancellation of removal. But adjustment of status, it's not it.